Today's video is brought to us by Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners with a 24/7 emergency hotline and plans designed specifically for self-defenders. They are offering a discount on their plan to ASP fans, so hit the link in the description for that.
Well, you know, John, here's one thing you got to keep in mind. The information that gets to the grand jury should, or any jurist, should be as pure and unbiased as possible. That's where we have rules like hearsay and things along those lines. There are evidentiary rules that are out there. So kind of like what you said, I don't know what the truth is. I don't know. I'm assuming the truth is Breonna Taylor did not have a gun. I'm assuming she didn't talk or she didn't shoot back or anything along those lines. But that grand jury knows everything that was listed there. We don't. And what we do today in society, unfortunately, something happens, we hear it, we run with it, we build on it, and then all of a sudden, you know, when the truth finally comes out, we've heard a lie over and over and over so many times that the truth is now actually a lie.
Yeah, and I do think a couple things. I know we started talking about this and I stopped you talking about it when we were upstairs because there's some things here that, first of all, some of these grand jury proceedings are sealed.
Yes.
And this one, the Attorney General decided, here's my entire case, and laid it out on their Facebook page. Like, had a press conference. Here's my entire case I presented to the grand jury. Here's all the evidence that I had. It's over, so I will release all of that evidence. And I think that kind of transparency in big cases like this, I find that to be a moral good because it lets people see what was presented to the jury.
Correct. I agree with that, and I think that was a smart move, you know, just like body cams, you know. People release those. Again, you get to see and decide for yourself.
Yeah.
But again, these people who are walking into the grand jury or any jurist, you know, whether it's in a criminal case or a civil case, you want it, one of the things the judge is going to ask you, what do you know about this? Can you put all of that aside and look at only the information that you're getting here? That's the purity of the system. And I think we lose that because we have too many talking heads out here, too many Facebook warriors, I'll call them, who are championing things that aren't necessarily true.
People that graduate from the law school of YouTube?
Yes. Yes.
Yeah. Hey, wait a minute. So, and I also think, okay, so those jurists, they also not only get the purest, hopefully, form of the evidence, but they get informed and educated about the law. So they get taught, this is what the law actually is. Here's how that law gets applied. Here's their jury instructions that says this is how you have to make this decision. Whereas the general public doesn't get any of that education when they're looking at things. They just think right, wrong.
Exactly.
And ought to be. And so I think that's a pretty big thing. Now, earlier, you and I were talking just a little bit, and I stopped him. This is the one I was talking about. Because I said, people are interested in how'd that warrant get sworn out? And I said, hey, should we hold the judge accountable who swore the warrant out? And no, on what evidence did that judge swear the warrant out? I do think there are times where we have confidential informants and those kinds of things that you don't want to burn. And so those kind of things can be redacted. But I looked at it and said, hey, listen, was the warrant sworn out on good grounds? Was it good for them to be there? Now, it looked like they had enough cause to get a good warrant because there's bad juju that was actually going on around there.
Right.
But you said you didn't like the fact that that you would scrutinize the warrant judge.
Well, correct. I mean, again, we've got another elected official, appointed or elected, again, depending, I'm not sure how they do it down in Kentucky there. But I'll say this, a police officer goes to a judge and he swears out a warrant, he or she. They swear out a warrant and they're raising their hand, they're taking an oath at that point that everything they're saying is correct. The judge makes a decision at that point. The judge says, okay, I know this officer, they put their character on the line, the whole 9 yards, and they look at everything and they say, okay, yes or no. But if we start going back at that person, at that judge, based upon what the judge knew at the time and what was presented to the judge, I'm sure you can find 50 judges that'll say, nope, I wouldn't have did that, or another 50 that'll say, yep, that was the right thing to do.
Yeah.
We, again, what's the information that's coming in? How pure is that information? And did this person, in this case, the judge, make the right decision? And I'm going to say this person had a valid warrant based upon the information that was given to the judge. They being the police, executed. The only problem I have with the warrant is the warrant became stale. And what I mean by stale is, I believe the warrant was issued either December or January. So 2 months later, is everything still up to place?
Execute it, yeah.
They should, in my opinion, they should have gone back and gotten another warrant. But again, that's a procedural issue that I would say probably happened between the police and some other things. Because again, I don't know that warrants necessarily expire.
Right. So somebody can say, hey, they should have resworn the warrant because the situation could have changed.
Correct.
I don't know that anybody's argued that it did change, that's the case. So, I'm trying to maintain some balance here and actually understand the system and understand why these things happen. And sometimes stuff happens that is tragic, stuff happens that is even wrong, and humans make human mistakes. And that happens for private citizens too. And sometimes, a private citizen can have a car accident that kills somebody, but it's not criminal. That it was caused even by a bad decision, but not necessarily by a negligent decision or a reckless decision that nevertheless causes the death of somebody. And that's tragic, but we wouldn't charge them.
Correct. I mean, I live in a state, I know it's going to be strange for you, but, we get in Michigan stuff called snow a couple of times a year. White stuff, kind of rain, but it's really cold, falls to the ground. I know, being from Arizona, but, snow and ice on the ground. And someone, maybe they're going 30 in a 25, and they hit their brake and they now start sliding, going 5 miles over, and they run into someone, let's say a kid standing by the bus stop there, okay? Tragic, yes. Is that something that we want to put someone under the jail for that?
No.
Again, that's something we have to think about from society's standpoint.
And I do think we hold our police to a high standard, and we should hold our police to a high standard, right? They're agents of the state, and they should be held to a very high standard, and we train them to a high standard. We invest in that and those kinds of things. And I also think that that's not speaking as well of the civil standard. That doesn't mean there's not a tort here, that there's not a wrong done that needs to be righted. And there will undoubtedly be a civil case between the estate and the family of Breonna Taylor and the city of Louisville and the State Department. And
it's been settled, actually.
Has it?
Yeah, my understanding, the city of Louisville settled for $12 million to the family of Breonna Taylor.
And of course, I mean, $12 million isn't going to bring back your loved one.
Correct.
And that it'll never make that right. But that's the city of Louisville, and I'm sure in the proceedings they say we admit no wrongdoing and all these things and all that stuff. But that's saying we realize something was taken from you that shouldn't have been taken from you.
Correct.
And so there's some form of compensation that the city of Louisville gave, and those are different things. So I just wanted you guys to understand the grand jury system, and I think when we understand the system, then we start going, okay, there's all these checks and balances, because the core at the end of our justice system is we want to get the right answer. We want to get innocent people are not put in prison, and people who are we have beyond a reasonable doubt we know did something that was morally evil are put in prison. Now, that doesn't always happen, and I'm not saying it always happens, but that's the goal. And so when cases like this happen, that's what the grand jury system is for. So
absolutely.
Well, thanks for the info, Terry, as tough as it is.
It's tough, but again, like you said, we learn it, we know better, and we'll get it figured out.
Yeah. Questions?
So the warrant was downgraded from a no-knock warrant to a standard search warrant?
No.
So he asked, the question that was asked was the warrant downgraded from a no-knock to a standard search warrant?
That's what I heard. I don't know if it's true.
Well, I don't know if it's true, but here's the thing. If you have a no-knock warrant, that doesn't mean that you have to not knock.
Right.
Okay? If you look at it in the opposite, if I have a warrant and I ask and I don't knock, then that's, knock and announce is basically the term. That's something different. But a no knock does not necessarily mean that, I don't have to knock. So, for example, if they would have went to the house, the door is wide open, and they just walked in, under that premise, under a no knock, you're fine. But walking in, and if there wasn't a no knock, and I don't know if I'm saying that right, wasn't a no, not a double negative, but if there was not a warrant for a no knock, they would have to announce themselves before going in.
Yeah. And they didn't. They chose not to regardless, so it's kind of a moot point because they did actually do that. Dave, do you have a question?
Mine's just a question on the procedural end of it. and I realize your state doesn't do it, but like I said, if you can do it from the federal. On the grand jury, they've got 24 people. It's a reasonable doubt sort of thing. Do all 24 of them have to agree, or can they cut it on 13 and 11 discs?
Let me ask the question
Sure.
first. So the question that we had asked was, we have 24 people in a grand jury. Do all of them have to agree that there's probable cause to issue an indictment, or is there a percentage that have to?
It's based on a percentage. And again, it varies by state and things along those lines. It does not have to be all 24. And again, in a grand jury, it's not, is the person guilty? The standard is there enough evidence here that the prosecution has made their case to move forward to a trial?
So we have a probable cause statement standard that a percentage, a not, at least a majority percentage, but not a unanimous percentage, have to agree to in order to move forward with charges. So again, this is a standard that is a very low bar for the prosecutor to jump in order to bring charges. So I mean, a lot of times, even if the grand jury indicts, that doesn't mean you're going to get a conviction. It doesn't mean that at all. It just means, yeah, you can move forward with the case. So it's pretty serious.
Yes.
Other questions? More questions?
Yes. Does the $12 million settlement, I guess from the city to the family of Breonna Taylor, does that eliminate the ability of the officer to be charged personally in the civil court?
So the question was, is the $12 million settlement from the city of Louisville to Breonna Taylor prevent the city from charging the officer in her death? Is that what you're asking?
For him to be charged civilly.
From charging the officer civilly. I have an answer, the attorney.
Well, it depends on how it's written. And what do I mean by that? If they determine that the officer was acting in his capacity as a officer when he did that, or if he was outside the scope of his training, things along those lines, it all depends upon how that settlement was determined. So I can't really answer that one way or another, but it's possible it is, and it's, again, possible it's not. All depends on how they crafted their $12 million deal.
I would say, generally speaking, if an officer is not given qualified immunity, so by qualified immunity, that means they are operating within the scope of their duties as a police officer, as an agent of the city and an agent of their community, under the auspices of the authority of the state. If that is taken from the officer, and you'll hear that this use of force was not within department policy, this was not within the training of the officer, therefore the city is not going to stand behind their actions, so they are denied qualified immunity. That's why it's qualified immunity. A judge in their place, in their actions as a judge, has total immunity. Like, there's no qualifications on the immunity, but the officer is qualified. So if that gets removed, then the officer is personally liable. I would think generally if the city offers a settlement, that is saying, no, this is on us, and this portion was on us. And probably my guess is that the officer is covered by their qualified immunity, and the settlement says, hey, the officer acting in this stead of the city, we recognize our responsibility in that shared.
But again, it just depends on how it's written.
Attorney, always going to say it depends. Any other questions?